So hopefully we'll be able to get kicking off now, and my session tonight is about preparing for adulthood. Preparing for adulthood is a huge topic. So what I've tried to do is break it down into some smaller segments that we're going to kind of do a whistle-stop tour through and ask some questions, and then we can direct you to other webinars that we've done to elaborate on those sections, and obviously we can answer any questions as we go along. So let's get kicking off. Oh, it would help if I shared my screen, wouldn't it? Just bear with me just a second. Right. Doesn't matter how many times you do these things, you still manage to not do it right on the night. Here we go. Perfect. I've already covered this slightly, but just to make you aware, obviously, the information that you hear in all of these webinars, they're not specific to your own individual case. And if you are seeking individual advice, then obviously please do contact us or seek legal advice as to your own individual case. Here is just a slide about what we're going to be covering tonight. I won't delay on this because there's lots for us to cover. But perhaps this time of year, the most important thing for us to be covering in the preparation for adulthood is transition reviews. Transition reviews aren't just for adulthood, they take place in the year before all transfers in phases of education. And I've listed there from the SEN regulations what we call a transfer year. So you've got, for example, infant to junior school, primary to middle school. And it's really important to identify when you are in one of these transition periods, and particularly obviously preparing for adulthood, you're looking at secondary to school to a post-16 institution, or post-16 to post-16, obviously post-19 coming into that as well. The statutory basis for transfer reviews is set out in Regulation 18 of the SEN regulations. Please don't worry about furiously scribbling down all of these notes. This webinar will be available after tonight, so please do relax, sit, enjoy a cup of tea and just listen in. You don't need to take furious notes, but that's why we've included all of the references for you. Regulation 18 also sets out the legal deadlines by when a local authority must review and amend an EHC plan. And this is prior to phase transfers taking place. And the reason why we point this out now is we know there are so many delays from when local authorities should be carrying out their annual reviews and transfer reviews and when they actually do carry them out. So knowledge is power. If you know when your annual review and your transfer review should happen, then you obviously can force it to take place. So 31st of March is the key deadline for a transition from secondary school to a post-16 placement. And it's 15th of February for all other transfers. And what we mean by that deadline is that is the deadline by which you should have a final EHC plan naming where your child or young person is going to go for that transition year. So for example, somebody going from secondary school to post-16 for September next year, you should have your final EHC plan the 31st of March this next year coming, and similarly 15th of February. So if you're going up to secondary school, you should have your final EHC plan. That's not when they should be carrying out the review. That is when you should actually have the final EHC plan document. I've also just included on here a timescales board for annual reviews. So these are the things that must be followed. For example, you should have 2 weeks notice of the review. I hear many times parents coming to me and saying they've been told that their annual review or transition review is tomorrow. If that happens to you, go back to your local authority and ask for it to be at least 2 weeks away, because you need to be able to adequately prepare. Preparation is key, particularly for transition reviews. Reports must be obtained and circulated at least 2 weeks in advance. The report of the annual review meeting must also be circulated within 2 weeks of the meeting. So if you have the meeting and you want to request a copy of the report from your school to make sure that absolutely everything that you've discussed at that annual review is actually contained in that report before it's sent off to the local authority, you've got that time at the end of the annual review to do so. Now, the local authority must issue a decision within 4 weeks of the annual review. So that's a really key date for parents to be aware of, because there are so many delays around this and it's a legal deadline that they must follow. So within 4 weeks of the review meeting, they must decide whether to keep the EHC plan as it is, to amend the EHC plan, or to cease to maintain the EHC plan, which we'll be going on to. If they are going to be amending the EHC plan, they must also send a statement of the proposed amendment. They can't just say we're going to amend it and not tell you what they're doing. So if they're going to be amending it, they must tell you exactly what they're proposing to amend. And that final EHC plan from that suggested change should be sent within 8 weeks. So that's why we're really highlighting these deadlines, because once you know when you should have your final EHC plan, you can work backwards. The final EHC plan should obviously name the type of school or the specific school that your child or young person is going to attend for that phase transfer year. The reason why we're pointing these out so much is because in order for these deadlines to be met, the reviews must take place with sufficient time for the EHC plan to be amended and finalised. Every single year, my team are inundated around February and March when they've realised that there's a deadline and suddenly annual reviews haven't even taken place, transition reviews hasn't taken place. Some local authorities also do their transition reviews early, so just be aware of that. That's been cropping up quite a lot this year, and lots of local authorities are actually conducting their transition reviews in the May before the transition. So where we're advising here, it should be around now, October, November time, you'd be expecting transition reviews to take place. Some local authorities are conducting them in May, and parents aren't actually realising that they're a transition review. So please do make, just clarify with the local authority, is this a transition review if your child and young person is going into a transition year? So for all students who are going from secondary school to post-16, we've got the deadline there, 6th of January, and for all other transfers, the 23rd of November. So these are really the dates by which we'd be expecting the annual reviews and transition reviews to have taken place, because otherwise, if they don't comply by these dates, then you're not going to have your final EHC plan on time, because you have to allow that period if the amendments are going to be taking place within the EHC plan. That's just set out here. It allows 4 weeks for the decision, and if the decision is to amend, it allows an additional 8 weeks on top of that. It is very rare for local authorities to meet this deadline. I know parents watching this will be more than aware, and many parents will approach me and say, well, I haven't even had my decision from last year. That's very easily resolved by a pre-action protocol letter. So if you are having those difficulties, you're well within your rights to get a pre-action letter drafted and get that across to the local authority to get your decision. If you have a child at a point of phase transfer and transfer review has not yet been arranged, you must therefore immediately seek for it, particularly around this time of year, October, November. Be getting a date in the diary so that you don't miss out. And the reason for this is because we have to allow enough time to go for a tribunal appeal if you disagree with what your local authority's decision is. That's why we've got the February and March deadlines, because by February or March, if you've got that final EHC plan and you've got your right of appeal, you've got enough time to go through the SEN tribunal process. If you get it any later than that, it's really difficult to get a hearing heard in the July so that you know where your child or young person is going in the September. So please, early preparation is key for transition reviews. This is just a slide here which you can look at in your own time. It just tells you exactly what should be included if the local authority, when the local authority issued their decision, so that you're aware of that. And I'm just highlighting again, the tribunal gets incredibly busy. We are now at the stage again where the local authorities, there's so many cases against local authorities that the SEN tribunal are actually vacating hearings. We haven't seen this since pre-pandemic. The tribunal have actually been fantastic during the pandemic and have been one of the only courts and tribunals to actually be running at full capacity and have fit in more tribunal hearings than ever before. But actually now we are seeing very often hearings that are vacated due to a lack of judicial availability and then having to be rescheduled. So please, early preparation is key so that you don't get stuck in this, because if you have a July deadline and your hearing is vacated, you're looking at September and your child or young person doesn't know where they're going to be going in the September. Transition review preparation tips. I have actually done an annual review preparation webinar back in January. So if you are in an annual review and want to know how to prepare for that, please do go and revisit it. It was a whole hour talking about tips and what you should be including. So I've just included a couple here just for key reference points. Do comment on transition review paperwork. We often find that there's, colleges want to tell everybody how well the young person has done, which is fantastic, and we do want to celebrate success. But one of the things that they sometimes do is they tell everybody how well the young person is doing, but they fail to actually say what support they're putting in place for that young person. And the bad thing about that is when local authorities see the report, they see, oh, this person's making fantastic progress, and they don't see the support that's going on behind the scenes. So that actually is taken out of the plan because they think that the young person doesn't need it anymore. So please do just make sure if you're highlighting success, you're also highlighting what support is going in place in order to achieve that success. Again, evidence stating progress without explanation. It's really important wherever there is progress that you're explaining how that progress is being made and whether that support is still needed to avoid it being unnecessarily taken out. You should always include the parent and the child or young person's views. This is really important because particularly if you're dealing with somebody who's preparing for adulthood, certainly the tribunal will expect to hear from the young person if they have obviously capacity and are able to do so. And they're being quite creative about how they do this as well. So in the annual review, certainly the young person, if they're able to, should contribute to the transition review about what their thoughts and feelings are, what course they might want to study. And if they're not able to do, their parents can do so. And similarly, if you're going to a tribunal appeal, the same thing applies. The tribunal are being quite creative. They're watching YouTube videos, they'll read letters, they'll look at drawings. They will do whatever they can in order to listen to that young person. Visit schools in advance of a transition review. If you have an idea that your local authority is going to be suggesting that not your preference of school is named, so you might be looking at an independent specialist placement for your child to go to post 16, and the local authority might want or have made noises about them going to the local college, go ahead and actually visit those colleges that they're kind of making noises about in advance of the transition review, so that when they suggest, oh, this is the type of college that can meet Jeffrey's needs, then you can actually come back and say, well, I've been there and I've asked them and this is what they can offer, and actually he needs this, so that's not going to be a sensible option going forward. So you're already prepared. Arm yourself with information going into these meetings. You can update the paperwork following the review. As discussed, there's 2 weeks to send the report, and if you feel like there's something that's been missing out of that document, you can add it to the report before it goes to the local authority. And just a reminder as well, if you are in or beyond year 9, the meeting must consider what provision is required to assist the child or young person in preparation for adulthood and independent living. So transition reviews, that's a bit of a whistle-stop tour, but you can also refer to the annual review webinar. And I hope that's giving parents something to think about, particularly if you've got a transition review coming up. You can go back at those slides, and if you haven't thought about actually demonstrating some of this progress, what evidence you might need, you can have a look at that and prepare accordingly. The next thing that might arise about children going to young adults and into adulthood is this educational social care? And I know this is prevalent. We get questions about it all of the time. And there used to be a distinction, obviously, when statements went up to 18 and then social care took over. And obviously, we don't have that anymore because education and social care should be working as one and the same. We know that doesn't happen in practice, but that's what should be happening is an education, health and care plan. So what actually happens is there's a lot of misunderstanding within local authorities, within schools, actually what is education and what is social care. And for any of you who are really struggling with social care and what you should be getting and what you're entitled to for children's social care and adult social care, my colleague Nicole at the same time next week will be covering a whole webinar on child to adult transition in social care. So that's the one to watch for that. Sometimes this is attributed, however, between funding pots in the local authority. It might be that the local authority actually agreed to fund X amount from education and X amount from social care, and that's why the confusion comes from. Also, sometimes educational settings, when you're approaching them for a placement, so you might be looking at a 52-week waking day placement. That placement might also break down their costs as education and social care, what they understand to be education and social care. And then that confuses things when you present those figures to the local authority as well. And you get this argument about this is social care doesn't agree with that, so this placement can't go ahead. So really we need to think about, okay, then what is education and what is social care? Section 21(5 of the Children and Families Act is your saving grace as to what is educational provision. So I've included the definition there. It is essentially healthcare provision or social care provision which educates or trains a child or young person is educational provision. That's so educates or trains, they're your key words in that definition. So what you need to be looking at is the impact of the provision, not who provides it or the intention. You need to be looking at actually what is that doing. It's not just actually the actual thing that's going on, it's what skills are you trying to teach this young person? Are you trying to teach them independence? Are you trying to teach them life skills? Because suddenly when you actually look at it in this way, then lots of things that would be traditionally social care are actually educational. Because, for example, doing laundry could be educational if they're learning to independent skills and to live on their own and to live in their own within their own means. So I've just put here some examples because it often confuses parents about what actually is educational provision. So input from ASD specialist advisory teachers is kind of a traditionally, you would expect this to be education, but speech and language therapy is also educational. Occupational therapy is educational. Physiotherapy can be educational. Behaviour management programs can be educational. Waking day curriculums can be educational, and independent skills. So things like travel training, all of those things which you would traditionally think perhaps is social care or healthcare are actually educational provision, and they should be appropriately put in section F of an EHC plan because they're educational. If they're not education, they shouldn't be in section F. So anything that educates or trains, the correct place for it in an EHC plan is educational. And be careful of anybody trying to move these out of the educational sections, because the legally binding sections of an EHC plan are sections B, F, and I. And if you move these things out of section F and then they are not provided by your college or your school, then you cannot fight them in the same way that you can if something is in section F. So it's really important that they're in the right section. While section 21.5 also applies equally to all EHC plans for all children and young adults, 0 to 25, we find this particularly problematic for those at the 18 to 19 bracket. And I think it is a bit of a layover from when we did have the traditional statements up to 18 and then social care took place. And nobody's really got to grips with it, even though we got the Children and Families Act in 2014. And 7 years later, we're still grappling with what's education and what is social care. We often find that local authorities will actually try to automatically convert educational needs into social care around this age, and that is certainly not what should happen. But we see this kind of running of the normal end of education at kind of college age before we go into post-19. And what we also sometimes find around this age is that you might have your child who's gone through school and college, absolutely fine with no difficulties. And then suddenly you're looking at post-19 colleges and the local authority is saying, oh, hang on a minute, your child doesn't need an EHC plan anymore because they're 19. This is something really real and really worrying for parents. So the next part I will cover is about ceasing to maintain plans in case you find yourself in that situation. Ceasing to maintain an EHC plan then, and why you should be aware of it. Traditionally, as I've said, we do have this problem where you get to 18 or 19 with no problems if you've been lucky. And I know there's plenty of parents looking at this and thinking, Hayley, I've had problems since my child was 2, 4, 6. You know, some local authorities will fight you every single year. And I deeply sympathise with those parents. But if you have, or if you are, you know, you might think, well, why do I need to worry? Should I be concerned? This is a particularly problematic age, 18 to 19, where EHC pleas are seized quite often. So what we'll be looking at, and this is the most dangerous transition period, it can happen sooner, but not often. It is generally around this age. We need to look at the correct procedure to be followed if your local authority is making mumblings about potentially ceasing to maintain your EHC plan. The Code of Practice, paragraph 9.205, where a local authority is considering ceasing to maintain a child or young person's EHC plan, it must inform the child's parent or the young person that it's considering ceasing to maintain, consult the child's parent or the young person, and consult the school or other institution that is named in the EHC plan. It is very, very common that we do not see that happen in real life. So what we'll often see is parents will approach us for the first time because they've just received a letter that the local authority has decided that actually what their child needs is social care, not education, and they no longer need their EHC plan and they're going to cease to maintain it. If you find yourself in that position, and it is an out of the blue decision that's been made, then the correct procedure is often not being followed, and you can challenge the local authority's decision for a pre-action letter. This is particularly important if you're in a specialist setting or an independent setting and you suddenly get served notice. So for example, a client of mine was served notice, 1 month's notice, that they were going to be ceasing to maintain their young person's EHC plan at a date in October. They'd got the letter in September. And at that point, this young person would have to come home. Their EHC plan didn't exist anymore. That is completely unlawful, completely unlawful. And what we're able to do in those scenarios is firstly write to the local authority and say, this is an unlawful decision because you haven't followed the correct procedure. So it requires the local authority to then actually go back and follow the proper procedure. So it allows you some extra time. Then additionally, if they still make the same decision, you get your 2 months in which you can appeal that decision to the SEN tribunal. And if you apply for a mediation certificate at the end of that period, you get an additional month if that falls later than your right of appeal. So parents who get a cease to maintain decision, please do not apply for a mediation certificate until you're towards the end of your right of appeal. And the reason for doing this is a local authority cannot seize a placement while there's an opportunity for you to appeal the decision or while an appeal is going through. So if you're quite clever with your timing, then what you can actually do is buy yourself nearly an additional year. So for example, in this case, in September, we wrote to them to say this is unlawful. They're going through the correct procedure now. If that decision is the same and they reissue it in November, we then have 2 months in which to appeal. So that will take us to January, another month on our mediation certificate, February, and you've already heard how long it takes to go through a tribunal at the moment. So realistically, we're looking kind of towards the end of July. So this placement is now secure for another year. It's really important for parents to realise that if you find yourself in that situation. Again, just highlighting there, overwhelmingly decisions about ceasing to maintain, we see all of the time, and often they haven't been done properly. So we can challenge them. It's important that you know that. In addition to requiring the local authority to consult with the parents and young person, the educational institution the young person is attending, the Code of Practice also provides some additional guidance as well. So I've linked them on there for you to have a look at, but generally it's around if you're in receipt of adult services, they should also be involved in the consultation about whether to cease to maintain. It should also generally be at the end of the academic year to allow the young person to complete their programme of study, and also notify the care commissioning group. So if you have got a social worker that you're working with and suddenly receive a cease to maintain decision, it's worth actually asking your social worker, were you consulted about this? Because if they weren't, again, you can challenge it as an improper decision. Section 45 of the Children and Families Act is the part we need to go to, because that sets out the actual correct legal circumstances in which a local authority may cease to maintain an EHC plan. And that is set out for you quite clearly here. A local authority may cease to maintain an EHC plan for a child or young person only if the local authority is no longer responsible for the child or young person, or the local authority determined that it is no longer necessary for the plan to be maintained. That's a key part here. The circumstance in which it is no longer necessary for an EHC plan to be maintained for a child or young person include where the child or young person no longer requires the special educational provisions specified in the plan. When determining when a young person no longer requires the special educational provision, a local authority must have regard to whether the education or training outcomes specified in the plan have been achieved. And I'd just like to highlight here, this is why we covered transition reviews at the start of this, because if we're looking at whether a child or young person no longer requires the special educational provision specified in the plan, if you go to your transition review and you present lots of progress, you know, Bella is doing absolutely wonderfully. She's, really come on, made fantastic progress since her last annual review. And don't say, well, this is because she's surrounded by a multidisciplinary team. She's receiving speech and language therapy for an hour weekly. She's supported by an ASD advisory teacher. She has a one-to-one, all of these things. If that's not communicated to the local authority and the local authority suddenly just think that this person has come on and made fantastic progress, that would imply that they no longer require the special educational provision in the plan. So that's why it's important to link these sections together. Similarly, the preparation for the transition review is key, because looking at this third point, the local authority must have regard to whether the educational or training outcomes specified have been achieved. When you're at that transition review or annual review, you'll be looking at outcomes. Outcomes are in section E of an EHC plan. So if you're looking through them and thinking, yep, that's been achieved, yep, that's been achieved, yep, that's been achieved, your next question is, okay, what else can they do? So they've achieved this one, fantastic, we celebrate success. What's the next step? So if your young person can now concentrate for up to 5 minutes on their own without having to be refocused, let's go for 10 minutes. And let's set those next outcomes. So we're always aiming for the next thing that the young person can do. So many times we see young people and children with SEN sold short, and it's frustrating for us working in this area because the fantastic things that they can go on and do, traditional success, we look at success in obviously all different realms when we're looking at SEN and disability, and what is success to us is sometimes even just very, very tiny outcomes. But if there is something else that can be achieved, then they must have regard to that, and that shouldn't be a reason to cease to maintain a plan. What does no longer necessary mean? So that first point that we had there, I'll just pop it back up for you, is whether the local authority determines that it is no longer necessary. And often the question we do get asked is, what is necessary? It's case law dependent. And I try not to bog these webinars down with case law because we try to make them as accessible to everybody, and we don't want to speak to you in traditional lawyer speak. For starters, a traditional lawyers just aren't that fun, and we just want to make them accessible for everybody. But that is the specific case name that you would need to refer to. And what this says is, for young people over 18, local authorities may look at whether outcomes have been achieved to decide whether an EHC plan is necessary, but it may also look at other things such as the young person's educational and training aspirations. Again, linking back to the transition reviews, that's why it's important to make sure you've documented the young person's views and what they want to be able to do when they're older, what they want to study, etc. The reasons why the outcomes were achieved, again, what is going in place in order to achieve those outcomes, and can more be set, and whether the young person's special educational needs profile has altered as he or she has matured. Because obviously we all get older, our needs change alongside our age. Sometimes we don't need as much support in certain areas. Sometimes we need additional support that we didn't need previously. If the young person has more to learn and can gain some skills that would be of benefit to them in adult life, then this supports that special educational provision should continue. It's so important. And all of those of you who have got young adults that you're preparing for adulthood, is really important, like I said, that if you haven't had your transition review yet, that you have a little bit of time to sit and look at these slides and look where you might have deficiencies in your transition review to avoid this happening. The SEN Code of Practice also sets out guidance about ceasing to maintain an EHC plan. And this says, in line with preparing young people for adulthood, a local authority must not seize an EHC plan simply because a young person is age 19 or over. Some of these things seem to be common sense. You'd think, oh, you know, and I'm sure there are local authorities that are watching this. They regularly log on to have a look, and that's great. If they're trying to inform themselves as to what they should and shouldn't be doing, then please watch away. But what we often see is people saying, well, we'd never do that. You know, that's not what we do. We see these letters. We see these letters on a, you know, particularly this time of year, daily, if not, you know, if weekly, if not daily basis. And sometimes it will say the young person is now 19 years of age, and so they no longer need their EHC plan. And I wish I could lie about that, but that's generally what we all see in the office. Nicole particularly loves challenging cease to maintain decisions, so she's very excited when she gets one in that she can write and set the world to rights as to what the proper procedure is. A local authority may cease to maintain an EHC plan only if it determines that it is no longer necessary for the plan to be maintained, or if it is no longer responsible for the child or young person, as per the legal for points you need to follow on the previous slide. Local authorities must not cease to maintain an EHC plan simply because the child or young person is 19 years or over. Again, just really important to hammer that home. I know I've mentioned it several times, but it's something that's commonplace that we really do need to see avoided going forward, and the proper procedure followed. If we're seeing the proper procedure followed and it is right that an EHC plan should be ceased to maintain, then we can obviously allow that to happen if it's right for that young person. But if it's not, you need to know about the ways that you can challenge these decisions, because they are often sent to parents, and parents don't have the knowledge or the ability to actually know that what they're doing is incorrect, because local authorities should be giving you correct information. If the local authority does not amend your EHC plan following your annual review and you have requested amendments, you've got a right of appeal to the SEN tribunal. If the local authority amends your EHC plan following your annual review, but you don't get what you've actually asked for, you will get a right of appeal to the SEN tribunal. If the local authority do propose to cease to maintain your plan, again, you will have a right of appeal to the SEN tribunal. So I'm just really highlighting here that even if you get a decision that's not, not going to plan, not the way you expected it to go, or you've had a successful transition review and you're actually thinking, that went really well, surprisingly, I'm really feeling positive about it. And sometimes parents do have this because they might have a SEN caseworker that attends the annual review and they have a positive experience. And then actually when they get their decision, it's, oh, we've considered all of your amendments, but in actual fact, we're not going to take any of them on and we're just going to leave the plan as it is. Then you can challenge those through the SEN tribunal. And again, just a reminder that if you are in a transition review, you really need to be looking at doing that now, getting a date in the diary so that you have got enough time to challenge it through the SEN tribunal if obviously the decision isn't what you want it to be. Don't be fooled by unlawful letters, which the LA officers think will end EHC plans. Agreement had been given for A to continue his studies at X for a further year only. That is something that we see all of the time, where local authorities try to give you a certain time period. So they might say, oh, we agree to this course of study, but this is only for 2 years. Again, they can't do that because that's why an annual review is there. It's to look at the young person at that time, what their needs are, what provision they require, and whether they need it ongoing. And we look at this on an annual basis. It's never just the case that this has been granted for 2 years and in 2 years it's going to be taken away. That is unlawful, so they can't do that. Timeframes following an annual review are legal timeframes that can be forced with a pre-action protocol letter. So just going back to those timeframes we discussed right at the beginning of this presentation, 4 weeks for a decision. If the local authority are going to be amending the plan, they should also send you the proposed amendments they're going to be making, and you should have your final EHC plan 8 weeks after that. So please do make sure that you familiarise yourself with those timeframes. What else do we need to consider for young adults? For parents of children and young people who lack capacity, and because obviously lots of this has been about generic, everybody who's a young adult, but for some unfortunate young people, they don't have capacity, they've never had capacity and they're not going to regain capacity. We might also need to look at an issue of deputyship. I specialise in deputyship. It's one of my specialist areas. I could talk about it for hours. I find it a really fascinating subject. So this is going to be a whistle-stop tour. There is lots of information about deputyship on our website. I've written blogs about it on Special Needs Jungle. I've written a chapter on it in Melinda Nettleton and John Frill's book, Navigating the Maze. So lots of information is out there about deputyship. But where appropriate for young persons that are approaching 18, a deputyship order can give effectively the same decision-making right that they were able to make as they were the child as a parent once they become 18. But deputyship isn't for everybody. And I just want to touch base really on the key points for deputyship before everybody thinks that they need one when they don't need one. Firstly, deputyship is only for those who lack mental capacity. So if your young person doesn't lack mental capacity, then you don't need a deputyship. That's very clear. If your young person does lack mental capacity, at the time a decision needs to be made, he or she is unable to make or communicate the decision because of an impairment of or disturbance of the functioning of the mind or brain. That is the technical definition under the Mental Capacity Act as to what capacity is. The difficulty about capacity is capacity actually is decision specific. So it doesn't just mean that a person is always not going to have capacity. Sometimes that's the case, but sometimes it's not. We can have a thing called fluctuating capacity. And in those scenarios, sometimes capacity has to be taken several times. So for example, it might be that a young person has capacity at certain times of the day, and as the day goes on and they get more tired or they're taking medication, their capacity is impaired. So for those people, deputyship is not the right course of action because obviously at times they do have capacity, and it would be more sensible to actually take their view on what they would like for their decisions actually when they've got capacity. Sometimes multiple capacity assessments have to take place in order to ensure that the young person does actually lack mental capacity. And I really hone this in because deputyship deputyship isn't for everybody. It is only for those that do lack mental capacity, and it's very important to make sure that you're not taking decision-making rights away from a young person if they can make decisions for themselves. Sometimes this is also quite difficult for parents to understand, because sometimes young people do make unwise decisions, and we have to ensure in this area of law that we're making sure that just because a young person makes unwise decisions, they're not actually lacking capacity. Unwise decisions, unfortunately, the Court of Protection can't protect against those. It's actually where just a person cannot make their own decisions because they don't have capacity. That's where deputyship could potentially come in. So if you were looking at potentially deputyship, first point of call is you need a capacity assessment, and we need to be sure that the young person definitely lacks capacity before we go any further. There are two different types of deputyship as well. There are health and personal welfare and property and affairs. Just to eradicate any of the arguments that I also see, it is possible to get health and personal welfare deputyship if the young person is suitable for deputyship and it is in their best interest in order to get a deputyship order. Certainly health and personal welfare deputyships are achievable. They are more uncommon, certainly, than property and affairs, but they are achievable. We've done them, we know that they are achievable, but sometimes, particularly if you're going to somebody who doesn't have experience in deputyships and what the application needs to consist of and the legal arguments that need to be made, then you may get an application rejected. So just make sure that if you think your young person fits the criteria for health and welfare, then actually you are getting the right amount of support in order to make that application. I've just listed on this slide what a health and personal welfare deputyship would include decisions about. So if the young person does lack capacity and can't make decisions, these are the kind of things that a deputy can make decisions over. And we've got a similar slide here for property and affairs. So you've got the traditional things like opening or managing a bank account, signing tenancy agreements. These are particularly important because somebody might lack capacity to make financial decisions, but they have got capacity to decide where they reside or what care they receive. So sometimes you might only need a deputyship for property and affairs because you might need to, for example, sign a tenancy agreement for a supported living arrangement. So I've just included an example of what you might need support with and also what a deputy might be able to make decisions on. Would I be able to get a deputyship order? I'm asked this a lot, and it's very difficult for me to advise, obviously, without seeing the papers and looking at capacity evidence, doing capacity assessments, talking about experts, etc. Things I would encourage parents to look at, however, if you're thinking, will I be successful in getting my deputyship order? When you're looking at property and affairs, you want to be specifically looking at is there any wills or trusts, or is the young person going to come into any money, essentially? Are they going to be inheriting a lot of money? Are they going to be left money? And actually they're going to get a pot of money that they're not going to be able to manage themselves. That's quite worrying for parents because they think if anything happened to them, would social services just get hold of that money? So sometimes that's a need for a property and affairs deputyship. How much? We call P, by the way, in Court of Protection, and when we're talking about the young person, your child, your young person, they're referred to as P, just in Court of Protection proceedings. So don't be discouraged if you see that reference anywhere. We might be looking at bank account. So if you've got a bank account for this young person and they can't go into a bank and manage that money and take the money out and know what they're spending it on, then sometimes if you've got regular gifts, so you might have grandparents that are giving this young person money, you want to give them money, pocket money, birthdays, Christmas, just as you would with any other young person, and they actually can't spend that and it's over a certain amount, then you might need to look at actually a deputyship order is more appropriate to manage that money. Similarly, if you've had difficulty opening a bank account for the young person because they can't open a bank account themselves because they can't understand the procedure or sign the forms, and you actually might need to open a bank account for them, you can do so with a deputyship order. Have you already tried the appointeeship scheme? So if it's just benefits that you need to manage, obviously you can be an appointee. Deputyship are things above just benefits. If you're only managing benefits, you can be an appointee for the young person and you can manage their money in that way. It's really when they've got additional things, additional bank accounts, inheritance, you need to sign tenancy agreements. They're the kind of things that you might need a deputyship for. Please don't fall into the trap if your young person lacks capacity signing a lasting power of attorney. Lots of parents, obviously lasting power of attorney is more commonly known because lots of obviously elderly people, adults might have done lasting power of attorney for themselves or their parents, grandparents, etc. They know about them a bit more than deputyship. And sometimes parents are actually advised, oh, you're going to need a lasting power of attorney. If your young person doesn't have capacity, they cannot sign a lasting power of attorney. It's really important because if a young person is signing a lasting power of attorney, they have to be able to understand the power that they're giving away to somebody else to make those decisions for them. And if they can't do that, you can't get them to sign a lasting power of attorney. What that will end up with is a messy court of protection case where the Office of the Public Guardian, if they realise that's happened, can apply to rescind the LPA and get a deputyship order, and it gets a bit messy. So just make sure before you're looking at lasting powers of attorney, deputyship orders, or if you're unsure which one you fall into, first point of call, capacity assessment, obviously get some advice from people that know what they're talking about in this area. Specifically in relation to health and welfare deputyships as well, the main, what should be happening for a young person is essentially when they get to the age of 18, they should be making their own decisions, okay? They can be supported in those decisions. And I know lots of parents just went, oh my gosh, the thought of them trying to make decisions on their own, they can't do that, they need my help. And I completely understand, and sympathize with that situation. What should be happening in that scenario is if the person cannot make their own decisions because they might not have capacity, then best interest meetings should be being carried out. So that shouldn't just be the local authority calling the shots. What that should be is a proper best interest meeting is held. The young person is able to contribute as far as they're able to, or everyone is in agreement that they can't contribute because they don't have capacity. And parents, the local authority, social care, the placement, any therapists working with them, so any doctors, speech and language therapists, occupational therapists, etc., should all essentially come together to look at what is in the best interest of this young person. Now, obviously, I act for parents. I know that this doesn't happen on the ground, and we know that often best interest meetings are set up without parents being invited, parents' views aren't listened to, local authorities make decisions on costs rather than need. If this is going on and you've got evidence of this, this again may be a reason why you need a deputyship order, because if you're not being invited to participate in best interest meetings, if decisions are being made on costs and not actually what your young person needs, again, these are evidence that actually best interest meetings have been tried, they're not working, and that's why we now need a deputyship order. Because we do have to also look at the level of consistency a young person needs. We can't have different decisions being made by all different people, because sometimes that can have very severe effects on a young person. So we also need to look at that as well. And if we're going to have different social workers every week and we're actually not going to have any consistency in decision making, again, that might be another reason we look at it. Are there specific decisions also that need to be made that cannot be dealt with by a best interest decision? And there are also different ports of call at the Court of Protection. You can get decisions for a specific decision. So it might just be that you want one question answered. So where might this young person live? And you just want a decision on that. And they can make a specific order, or you go for a full deputyship order where you can obviously make the decisions as if you were that young person making them. And that has to be somebody who knows the young person well, who would make decisions as if they would, essentially, if they had that decision capacity making power. So it's really important that deputyship is understood and it's applied for correctly and in the correct means, because nobody wants to waste time and energy, money, and money is time as well. It's lots of paperwork that you want to go through just to be rejected. So make sure that you do your research before actually going into deputyship. But if it is something that you think your young person might actually need, then obviously that is something that we can obviously discuss. I know that was very much a whistle stop tour, and I am going to invite my colleague Nicole on in a second, because I'm sure you've been furiously typing away in the questions. It's somewhat of a world record for me to get through any presentation in less than an hour, but I was actively looking at my watch and trying to stick to time before we're joined by Nicole. One thing I just want to highlight for parents, specifically if you missed the beginning of the webinar as well, please make sure that you are looking where you're getting your advice from. I know parents, not all parents can afford privately funded advice, and I don't expect every parent to be able to, but there are lots of really good resources out there that provide really good information for parents who perhaps can't access privately funded support. And also we've got the solicitors' practices that do have legal aid contracts, such as Quorum Children's Services. They've got a legal aid contract. So if you are legal aid funded, you can obviously go to them for some support. what we're seeing at the moment is a really worrying trend of parents and advocates and advisors who I have no doubt want to do their very best for parents and might have gone through this procedure themselves and, you know, run their own tribunal appeal, and they're advising other parents. But we are seeing worrying cases going to tribunal and, you know, wrong law being applied and just some very worrying things. And this was echoed in the SEN tribunal user group meeting recently, where incorrect advice is being given in kind of these big groups where parents share their concerns. So certainly, you know, we are here, we are solicitors in this practice. That's all we do. We only act for parents. We don't act for local authorities, and we can certainly help if you're looking for legal advice. Similarly, obviously there are other law firms out there if we're not the right firm for you, and there are obviously Quorum, etc. There are also, you know, IPSI and people that you can get advice from, but I just lay a word of warning. It's not anything against them. I just get really frustrated when parents end up coming to us after spending a lot of time and money with other people, because lots of these people are also charging a lot of money for their services, sometimes more than solicitors are, and it's just really worrying, and we're seeing a really worrying trend. So if you are getting advice, please do make sure it's from the right people and that you're making these informed decisions, because, you know, it really frustrates us that children and young people aren't getting the support that they should legally be getting anyway. It pains us when parents have gone through this and have to go through it again to get the right results. So just wanted to make a side note about that. Hopefully everyone's still here and you haven't all dozed off. Before we just quickly go on to questions, Nicole, as well, just a reminder, this is the very start of our webinar series. We are running these every Tuesday and Thursday across the whole of November. So every Tuesday will be a legal webinar. You'll be speaking to me or one of my lovely team, and we're covering a variety. Nicole is up next week. She'll be talking about social care. And then every Thursday, what we've done for this one for the first time only is every Thursday we've put on an expert witness as well, or, you know, somebody who's expert in their field. We've got a speech and language therapist coming on to talk about the differences between developmental language disorder and autism spectrum disorder. We've got we've got fabricating your child's illness, parents who are being accused of that coming up. We've got this Thursday coming up, Melinda Erickson, who's an occupational therapist, talking about what is sensory integration. I sat in on the recording of that yesterday, and that is absolutely fantastic. It's mammoth, it's about 2 hours, but there's lots of advice and tips and strategies that she's included in there. And we've also got a SEN support strategies session where we've kind of cobbled together lots of resources who we support and we know do excellent work for parents. And that can range from people who can offer kind of days out and trips for SEN children, disabilities, to where you might go to get some advice or some counselling for parents, or just a parent group that you might turn to. So we've tried to include everything in this webinar series for you, and it will run every Tuesday and Thursday. All of the sessions will also be recorded and they will be released onto our website and our YouTube channel. So if you miss anything, please go on there and access them. They're all available for free. And as I said at the beginning of this webinar, obviously, if you do like what you see and it is helpful to you, please do reach out to me on Twitter, Facebook, all of the social medias. You can write to us at customerservices@senlegal.co.uk, because these are the reason we do these. We do them all in our free time. So we really hope they're helpful for everybody. So Nicole, without further ado, sorry, I kind of spoke for about 5 minutes. If you're around, do you want to come off camera and ask some questions? I'm sure you've got plenty.
Hello, I am here. Hopefully you can all hear me.
I can hear you.
Hi, everyone. Just in the spirit of, as Hayley said, doing it in free time, a bit of a warning. I am at home with dog and daughter. Dog has made appearances in webinars before today, and she might do today, but fingers crossed she doesn't. We've had some really fantastic questions in, actually, Hayley. A really good mix across the different topics. So I'm going to try and whiz through a few of them. There are 42 open, but I've tried to pick sort of a cross selection. So the first question is from Sally Cady, and she is looking at post-16 and specifically 5-day packages. She's come across the fact that lots of these packages are only 3 days. And the local authority is saying, of course, that the additional 2 days would be social care. But social care saying that their child doesn't meet the criteria for that additional support. So what do they do about that, and how do we show that this is educational rather than social care provision?
Again, that would be looking back on actually what is going on those additional 2 days. So it's all right, then local authority saying, well, actually, that is social care provision, but what is that provision actually doing? So is it educating or training? My guess is, as I'm sure your guess is, Nicole, that actually what is going on here is educational provision, because it will be things like life skills. And also you should say to the local authority, what is it that they're proposing on those 2 days? Because they can't just say, well, actually 3 days, that's all we're going to be giving you. So what are they going to be doing on those additional 2 days? Are you going to be getting therapies on those additional 2 days? Are you going to be, working with a support worker, accessing the community? Are you going to be going into shops and actually looking at how to spend money, what change to receive, all of that kind of things? All of those things that are the traditional social care, we often see are educational. So the chances are that this person is actually getting an educational package, but the local authority thinks it's social care. So again, it will be looking at those slides about what is education, what is social care, and making arguments about why they are educational and not social care, and also being very clear that the local authority can't just offer 3 days worth of provision, they should be providing all 5. So hopefully that helps.
In the interest of giving bang for buck, Sally's question is actually a bit two-pronged, and I think it's worth asking the second half as well. So her son would like a particular college, which is a sort of equidistance between the 2 colleges on offer. The LA are veering towards the one that her son doesn't want. So what rights does her son have in respect of getting his choice?
Again, what we need to look at, firstly, obviously the young person's view should be listened to. He is the one that's going to have to go to the college. You'd also be looking at what type of college it is. So if it's just 2 maintained colleges, it would be very unusual for a local authority to fight that, because ultimately we all know that decisions from local authorities come down to costs. So we'll be looking at what type of provision. It might be that this person's son wants to go to an independent college and the local authority wants to suggest a maintained college. So that's obviously something that we would need to look at. There are 2 different ways, certainly if you're going to the tribunal, that you can win essentially your chosen placement. Firstly, can both settings meet your son's needs? So obviously you need to go to both colleges, have a look at them. Obviously the college that your son specifically wants to go to, that they can meet his needs, but the other college, visit it and ask, can they deliver the support that your son needs? Can they deliver the course that your son wants to go to? Because that's quite often what we see. The college that the local authority is suggesting actually doesn't have a course that your son wants to attend. Go and actually speak to the staff. Are they trained? Are they experienced? Have they got the right therapist? Because if not, if you can prove that actually they can't deliver the provision, that's the end of it. They have to name your choice of school, or certainly you can go to appeal to get that named. But also we look at costs, and we'll be looking at the totality of the cost of the local authority's choice of placement against your own. And if they're similar, then the law says that parental preference should be named, or young person's preference in this case.
Thank you. This is a question from Gandhi. I think this obviously relates to when you were speaking about if a decision is to amend following a review. Should the draft amended plan be sent out with a decision notice? And I did see some other people asked a similar type of question, so hopefully this will be helpful for a few people.
Yeah, definitely. So if at that 4-week mark, obviously the local authority have to decide, do they need to amend the plan? Are they keeping it as it is, or are they ceasing to maintain it? If their decision is to amend the plan, they should send out a statement of changes. So it will be the draft EHC plan, or they're going to set it out on a separate document. However they decide to set it out, they need to tell you what they're going to be amending, what those changes are. And then 8 weeks later, they should produce the final, must produce the final, I should say. So when you get that decision, if it says we're going to be amending the plan, go straight back to them and say, where's the statement of changes? And again, I've given you the reference for that earlier on in this presentation. So if you are getting any decisions that say we're amending, go back straight away, ask what amendments are going to need to be made. So you have fair time to comment on those changes, because obviously if you don't agree with them, you can go back to the local authority in that 8-week period as well.
Thank you very much. I think this is relating to phase transfer. It's a question from the barn. So is the process the same, the phase transfer process the same when a child is in year 11, but they're in a straight through setting that actually goes up to 19? So will the phase transfer trigger?
Yeah, so phase transfer triggers on age, so that's absolutely fine. It's just a pinch point, and obviously the main, obviously Nicole didn't ask this, but just to make parents aware, the main pinch points that we see are children going from primary to secondary, and secondary from post 16, and sometimes post 19 to post 19 as well. But yeah, the transition will always trigger. Obviously, if you're in a settled placement, that's great because you've already got the evidence. You've already been accruing the evidence actually that they're in a setting that's supporting them. You're very happy, they're making progress. That actually makes your life somewhat easier that you've already got that documentation from the college. But yeah, it will still trigger just because of obviously their age and what year they are phase transfer, regardless of whether the placement goes all the way through. You just might not get as many problems, because where you tend to have the problems is when you're leaving one setting and going into another, because local authorities look at it as an opportunity to actually review all of the children and young people in that bracket. Essentially, when they get a transition, they think, where can we obviously bring people back into borough if possible.
Thank you very much. I've got a question here from Joe Major. I've opted to answer it live because I just like to keep you on your toes, Hayley.
Thanks,
you didn't actually talk about it today, but Joe is asking if there's any information you can give about deprivation of liberty safeguards, because it's been raised by a social worker.
Oh, deprivation of liberty safeguards, the long awaited deprivation of liberty safeguards. They are actually changing to liberty protection safeguards. So this has been in the mix for a good number of years now. Deprivation of liberty safeguards are there to protect the young person, and essentially they are there to make sure that somebody is not being deprived of their liberty unless it's appropriate to do so. So some young people are deprived of, or adults are deprived of their liberty because, for example, they cannot keep themselves safe and they might have to be locked in at night to stop them leaving their accommodation, going out into roads, etc. And if we're in agreement that actually those safeguards have to be put in place to keep that person safe, that adult safe, then obviously we can get a deprivation of liberty in place to make sure that it is in place and it's keeping them safe and it's in their best interest to do so. If there are any concerns about the way deprivation of liberties are being used, and certainly I've had this recently, I've had an adult, very much an adult, kept in a mental institute under a deprivation of liberty safeguarding decision to keep them in there because they've said that that's why they need to be kept in there. They're safe. You can challenge that by a section 21A application in the Court of Protection. Again, far too wide ranging for me to talk about tonight, but certainly you can challenge them. So if anyone has got anyone being kept anywhere under a dole's and are a bit worried that it's not right, then certainly there are ways of challenging it. But just to make parents aware, if they are hearing about deprivation of liberty, you don't need to necessarily be really worried. It's very common, particularly for people that are restricted in some way for their own safety. They safeguard the officers that actually come and assess for doles generally are quite helpful. So if you have got questions and concerns, you can address that with them. But they are also, just to make parents aware of the terminology, deprivation of liberty safeguards are changing to liberty protection safeguards. They should already be in place. They're not. We're currently looking at about April next year, but obviously I'll update people as that changes. But just in case you see different terminology, they are going to be changing from doles to LPS in the future.
Thank you. I think Richard's wanting to keep you on your toes as well. He has selected as a live answer question Mandy's question. She has a national trial appeal running and it looks like the tribunal is imminent. The local authority have asked the parent to complete a multi-agency referral form, which, for those of you who aren't sure what it is a form that would normally be filled out by a professional if they're concerned about safeguarding or the fitness of the parent to parent. And because the parent has refused to fill this out, the local authority are saying that there is no social care assessment to contribute to the tribunal. Do you have any advice for them?
Do you want to answer that, Nicole?
I'm happy to answer that, Hayley.
Social care
next week.
Yeah, that's what I was going to say.
There's quite a lot of social care in here. So all of you that have come on to ask questions, do come back next week and I'll cover them for you. But to answer Mandy's question, quite right. If there is no safeguarding concern, then I would really question why a multi-agency referral form has been asked to fill in. And I think you should be recommending those parents, if it's not yourself, to come along to Kathleen Long's presentation at the end of the month, which is looking at induced and fabricated illness, because that might be what's going on behind the scenes here. I would be saying to the local authority, why isn't a child in need assessment not taking place under Section 17 of the Children Act? That is what should be happening. And you would be well advised as well to look at getting your own social care evidence. So there are independent social workers out there. Kathleen Long is one of them. She's a very good one, who can actually contribute and provide social care evidence. The risk that you have with the national trial and the social care elements of the EHC plan is firstly that they're not binding decisions, they're only recommendations. So the local authority may turn around and refuse to follow any recommendations made anyway. And secondly, the tribunal really don't tend to take it any further than the evidence before them. So if everybody's turning up with no evidence, I would say there's a risk there that the hearing would get vacated. It says the tribunal's coming up. There may be case management coming up, at which point they may say it's not ready to be heard. So just as a warning. And secondly, if you do turn up with no social care, they may well just go ahead and deal with the education sections, or give the option, we'll deal with education today and make this, and resolve the appeal, or you can go away and come back later with social care evidence. So that's something that you're going to want to be addressing.
We've probably got time for just one more question, Nicole, but just to remind everybody who's in there, because I can still see, we get this every webinar and it's why we love doing them and love parents' feedback, because we know how helpful they are. And there's 48 open questions. So I can see James and Richard furiously typing away in the background, trying to get through as many of them as possible. We'll do one more live, but just a reminder, the reason I threw that back at Nicole absolutely loves talking about social care. So she is going to be covering a whole webinar on social care next week. So anyone who has got a social care question, who hasn't had the opportunity to have theirs answered this evening, we will be here. Well, we will be here the same time at the same week all through November. We'll be here every Tuesday night at 7 p.m. till 8 p.m. So different subjects, obviously, but please do dial back in next week to Nicole's social care webinar if you haven't had the question. And if anyone hasn't seen which webinars we're covering and the topics we're covering and who we're covering them with, they're all listed on all social media platforms and also on our website. You can also see on there the ones that are live, where we'll be obviously like we are tonight, and also the ones that are pre-recorded. And for the pre-recorded ones, you're able to send in questions in advance, so we can still answer them for you. So if your question hasn't been answered, you've got ways of obviously contacting us before, and also we can deal with them live. So make it a good one, Nicole. One more final question.
I'm going to pick a really good, there's so many good ones out there. And I'm trying to make it something really, really different than what we've discussed so far. We've had a couple of questions on it, so I'm going to ask Jackie Buick's question. Other people raised it as well, and it's actually something you and I were discussing just today, Hayley. It's looking at these childhood, I can't remember what they're called now, the bank accounts that were opened, which are now coming to maturity. And of course, there are various young people out there who were disabled and still are disabled. Thank you very much, Elaine Bell. It's the Child Trust Funds. Join Elaine next week, where she will answer all your questions. So what can they do about that? So the two questions that I've seen are, how do they go about accessing them? And two, someone had read that the government had now waived fees in respect of parents who are applying solely to access these accounts. And is that the case?
Yeah, so you done the research on the access to that. So do you want to cover that, and then I'll cover the general deputyship answer?
Yeah, of course. So there's a huge amount of lobbying out there at the moment, and these lobbyists are trying to bring in a complete sea change to say that you don't have to go through the Court of Protection to access these child trust funds, because it's massively laborious, as if you don't have enough to do anyway. But at the moment, that's not the case. You are going to have to go off at the moment and apply through the Court of Protection to access the child trust fund. And the answer is yes, the government have agreed now they will waive the fee for people who are trying to apply for those, for access to those child trust funds.
Just to cover as well, if you've obviously, we set out the reasons why you might want a deputyship for property and affairs, and if you do find yourself needing deputyship, you don't always have to pay the application fee anyway. There are certain fee remissions that you can get. So if you just go on, Google and type in court protection fees, you can read up about whether, because it will go on, obviously, some depending on which deputyship you're applying for, will go on yours or the young person's, how much they have got in their bank account. There's a certain amount, whether they're access to benefits. So sometimes you can get a reduced fee for applying for court of protection, and sometimes there is no fee, and sometimes you can pay the fee and get the fee back. So just to be aware, there are fees associated with court of protection, but you don't always have to pay them depending on your financial means as well. So just wanted to make parents aware of that. Unfortunately, we do have to call it a night, as much as we adore talking to you all. Certainly for Nicole, she's got a child that she needs to get to bed, who will be very happy that her mum is on here talking with us all and not encouraging her into getting into bed this evening. But like I said, these webinars are going to be available every Tuesday and Thursday throughout November, purely for your information and to make sure that everybody is able to access information irrespective of their means. So we really do hope that they are helpful to everybody. Nicole and I, as the dangerous duo, will be back next Tuesday, when Nicole will be presenting on social care and I will be picking her brains on behalf of you all, and we'll be answering questions behind the scenes. And then Richard and James will also be coming on later on in the month to talk about transport, non-SEND remedies, and also we've got those expert sessions that we've got coming up. Some of those are pre-recorded, so Melinda's was pre-recorded that we had the pleasure of doing yesterday, and we've got people who are also live, so a lot of our experts are also live, so we can ask questions. And also we're making sure we get those support networks out there so that you're not isolated and you're not on your own, and really hoping to empower parents as to what support is out there for them. So hopefully you all found it very useful. We just thank you for your time, for joining us. We really do appreciate everybody dialing in and wanting to talk to us. It's really, really lovely. So thank you for your time this evening, and we hope it was helpful.